Good morning, everyone. Thank you for coming. Really, first and foremost, want to give credit to all of the lawyers and staff involved in this litigation. I think what we saw today was some tremendous advocacy on behalf of the states that are participating in this case and on behalf of the individual plaintiffs. And want to emphasize two quick points, and then I'll turn it over to Matt Adams to speak as well. This is an incredibly important case, and as was noted by our Solicitor General today, Noah Purcell, the absurdity and the radical nature of what the Trump administration is arguing today. What they have been arguing today and have been part of their arguments since the beginning of this unconstitutional executive order is to overturn over a century of law and precedent and Supreme Court holdings in the United States, to change the way that multiple presidents, the Supreme Court, and Congress has interpreted the birthright citizenship clause of the 14th Amendment. We're not just talking about changing a new law or a new precedent. We're talking about overturning the fundamental understanding of what it means to be an American in this country and what it has meant since the 14th Amendment, and what the Supreme Court has said time and time again of what the birthright citizenship clause meant when it was passed with the 14th Amendment. We're also talking about upending the lives and identities of citizens of this country who, through a stroke of a pen from the president, would no longer be citizens in the United States, and the absurdity and harm that would come from that. And so I'm really confident moving forward that this court and ultimately the Supreme Court will rule in the state's favors. But obviously we've seen some radical ideas take root at the highest level of government. And so it is more important than ever the attorney generals here and across this country are standing united to fight against the unlawfulness of this president, to make sure that we protect the bedrock principles of this country. But I want to turn it over to Matt Adams.
Thank you. So I'm with Northwest Immigrant Rights Project. We're representing the individual plaintiffs and the proposed class members, or the individuals who are directly affected by this executive order. As we said in court, one of our plaintiffs gave birth to her child roughly 1 week after the effective date of the executive order. And but for the district court's action, would have been left unprotected. And her mother comes to us still and says, what's happening now? What's the status today? Still concerned about how this is going to affect her child, whether her child's going to have access to health care, to education. These are the very real concerns they're living with. And now, with the ever-present threat of immigration enforcement, registration required even for children, that's the threats they're facing, even though under, as they said, over a century of law, it's clearly established that they're U.S. citizens. And I think one of the most important points is it's not just about how the case has been interpreted in the courts. It's about the president's authority to rewrite the Constitution. The president has a massive authority, but what he does not have is authority to rewrite the Constitution, to change things that he doesn't like. And that's what we're here to do, is to ensure the rule of law, to ensure that the president is not permitted to overstep the bounds that he's confined with by the rule of law, which are central to our democracy. And we are confident that moving forward, the courts are going to continue to uphold the rule of law and protect our plaintiffs and make clear to all that they are, in fact, citizens.
And with that, happy to take any questions.
How concerned are you that one judge brought up twice that domicile is mentioned 20 sometimes, and how do you think that might affect the case going forward?
Well, I think the court, had a lot of pointed and difficult questions for both sides to grapple with, and that is what we anticipate and expect at any Ninth Circuit argument or any Circuit Court of Appeals argument. We expect the jurists to ask difficult questions of both parties. That's what we saw today. I think, as Noah pointed out, however, that what the plaintiff's position, the government's position today is not only re-arguing that one specific case, but essentially asking the court to overturn how the Supreme Court itself, time and time again, has interpreted that clause. And so I think those questions were anticipated. They were pointed. Noah and Matt did a great job responding to those issues. But again, there's multiple court precedents after the Kim Wong-Ak case reaffirming exactly what the states have said today.
What did you make broadly of questions from the judges? They certainly seem much more open to the Trump administration's interpretation than the district court judge did.
Well, we always see more thorough debates at the circuit court level than we do, particularly when we're moving for a TRO or a preliminary injunction, where there's been full briefing on each side. I think it's a healthy part of our democracy that we have this process. When a president acts, we believe it's unconstitutional. We go to court, have an opportunity to debate these issues. We were also at the Supreme Court last month when these same issues came up. And, you know, I keep having the sound of Justice Kagan in my mind when she said, let's assume that you are dead wrong to the United States of America. I suspect she would have said the same thing today. Ultimately, obviously, this issue is going to go to the Supreme Court. But that sort of healthy debate on the merits is expected, anticipated, and a function and a core of our democracy. It's a good way to move forward.
What are the consequences if this, you said it's going to go to the Supreme Court. What if this appeals court goes against you? Are there consequences in the interim for your clients while you would then appeal that decision to the Supreme Court?
Oh, absolutely, there are consequences. Matt, I don't know if you want to speak to your clients individually, but I can speak on the states.
Sure. I mean, as I explained about one of our plaintiffs, even though the district court has already ruled in their favor, there's still that constant threat of how this is going to impact them. So absent an injunction, regardless of how it's ultimately resolved.
You can pause for a minute.
Yeah.
Go ahead.
But just to respond, even in the interim, if the injunctive relief were lifted until there was ultimate resolution from the Supreme Court, it would have drastic consequences on the individuals who are directly targeted by this, putting their whole life as it stands in the state of uncertainty and fear. We've already had clients who've approached us who had taken their children out of school because they were concerned about the impact. And so it's so critical that the courts continue to resoundingly reject this attempt to overturn what is well-established law.